Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We got a question here from YouTube user Demonquez. Demonquez for Prez. For the record, I don't know if Demonquez means something. I don't know what it means. So if it means something good. It means something bad. I was going to say don't cancel me, but go ahead. I'll get a vacation. Demonquez asks us, hey, I've got a question, Vince. I was employed at a fire department and I was a victim of racial discrimination, retaliation, and I was forced to resign by them because I didn't want to cut off my traditional locks. Okay. I'm also using a mental health professional to treat my emotional damages. Amazing. So do local government entities such as a fire department tend to settle these disputes sooner and compensate much more if you have audio recordings and much more significant evidence? Do these things make my case more valuable? I'm looking forward to hearing your response. Thanks. Listen, more evidence is always better. It's always tough. So hair discrimination is tough. So it's not protected the same in all jurisdictions. Should be, certainly. There's also an issue specifically with fire departments that I will get into right now. Without touching the case law, without doing a survey of the case law, I'm not going to draft you a memo on this. I am familiar with a fair number of firefighter cases. And firefighter hair cases, traditional hair that doesn't fit under a helmet, can be tough. And I'm going to play devil's advocate, demon's advocate, not Demonquez's advocate, but demon's advocate for the fire department. If you are running into burning buildings and you have long hair of some kind, traditional, not traditional, whatever it might be, maybe let's go with the less controversial headbangers, 1980s, white snake, long hair. Before we apply the more meaningful traditional hair test to this, okay? If you put it on, like you have your hair and you put your helmet on, your helmet potentially comes out of, your hair comes out of your helmet. A couple of issues. Right off the bat, burning building, you have fire retardant gear, you have hair flying loose. Legitimate safety issue, hair catches fire because it's not sequestered underneath the flame retardant gear. We have a problem. Second problem, firefighters routinely need to use oxygen. Oxygen masks must seal. They must have a seal to the face to keep out toxic chemicals. If you're wearing your white snake hair, you got your helmet on and you got your respirator on, and your wispy little hair, your white snake hair, bleach white hair, gets in the respirator mask. Guess what you don't have? A seal. No seal. Problem. Now you're sucking smoke. You're a smoke eater, right? To steal the common phrase for firefighters before the respirator. That's a problem. Lastly, and not very meaningful for the white snake hair, but somewhat meaningful, so we'll stick with it. The hair could be hung up on something or trapped in something, right? Something collapses or a door slams shut or some rebar falls and it pins the hair. It could slow the firefighter's movement. These are all legitimate safety issues. Now, does anyone have a deep-seated need to have white snake hair? Not that I'm aware of. There might be someone out there. But I'm not currently aware of a protected class to which white snake hair from an 80s rocker band is that meaningful. As someone recently said to me, metal is life! But I would contend, potentially, that where metal is life, but could become death, we've got to balance things. Now, I don't know where I come down on the issue of traditional hair in a firefighter helmet. I'm very lucky that I've never had to decide that as an arbitrator, because I do fundamentally believe in the unassailable importance of traditional hairstyles. You say you have locks. Now that could be short, right? That could fit under a helmet. And if it fits under a helmet, truly fits under a helmet, and is unquestionably not a risk for your respirator, I think I say good to go. I mean, good to go. We don't need to attack your traditional hairstyle if there's no actual legitimate fear or concern, right? I mean, that's pretty simple, you know? Let's complicate things. The traditional hairstyle, the locks. Demon Quez is lovely. I presume long-grown, work-intensive locks. Crafted through extensive time spent. They're long, though. They don't fit in the helmet. There's no way to make them fit in the helmet. Can we think of a fire retardant solution? Can we think of something that is as safe as the current helmet and bunker jacket setup, which keeps firefighters safe? And if we can, again, I would say good enough. Just my thought, where I come down. Now, locks might not be a real risk for breaking the seal on a respirator, but I don't know. In fact, I may never know, because it is in fact my goal to never wear a respirator for as long as I live. But if it's not a risk, amazing, then we're good to go again. If it is a risk, or if it slows down the application of the respirator, that's complex. I don't know where we land on that one. That one's tough. So I went through this long discussion, Demon Quez, to say, one, check the case law in your jurisdiction. There's going to be decisions on this. These decisions will touch upon other firefighters, but also prison guards and police officers. There's going to be a lot of cases on this. They're going to touch on beards that interfere with respirators. They're going to touch on hairstyles. This comes up often. In our office, we see maybe 20 of these a year, believe it or not. They are never easy cases. They are complex cases. They are fought not for money, generally, but they're fought for a depth of belief in the hairstyle, the beard, the whatever it is that has deep and abiding meaning to you and your identity in the world. Generally, these plaintiffs are fighting for that. It's not about the money for these plaintiffs most of the time. It's never really about the money in this field. That's a myth of this field. But generally, those plaintiffs are fighting for their right not to party, back to 80s hair bands, but they're fighting for the right to retain their identity, their hair, which is meaningful to their identity. Excuse me. Now, is this a big money case? Well, you've resigned. So you're going to have to make a constructive termination argument. That is more complex than if they had terminated you. Doesn't mean it's bad, just means it's more complex. Might introduce a little more risk. Fire departments, municipal bodies, county bodies, state organizations, local entities, government entities generally are less prone to settle because they're not playing with their money. They're playing with your money. They're playing with tax dollars. So if you score a $1 million verdict against them, no one involved, no one who did a bad thing is cutting a check. The taxpayers are cutting you a check. This leads to questionable decision making on the department's behalf, often, routinely. So often these cases will have to be fought longer and harder and will be more complex and more viciously litigated than you might otherwise see. It's good that you're treating for your mental health damages. I love that. It's good that you have great evidence. I love that. Your evidence could be everything here. But I don't want you to get the wrong idea that this will be a walk in the park. It very likely will not. I'm sorry. Could be a great case. I'm not saying it's not a great case. I'm not saying you're not right. Simply saying this is unlikely to be a walk in the park. I hope this is helpful. Good luck to you. Like, subscribe, comment down below. Share our channel so it can grow. Thanks, everybody.